Hi, my name's Esther Ifan and I'm a paralegal at Wendy Hopkins Family Law Practice. Today I'm going to speak about prenuptial agreements and specifically Petnups. Prior to marriage, many people consider signing prenuptial agreements or prenups. Prenups are most often used where someone has accumulated assets prior to meeting their partner and they wish to determine how they would split those assets in the event of a divorce. Whilst prenups are not legally binding, they do indeed carry some weight in a court, provided the relevant criteria is followed. Not many people, however, would consider what would happen to their pet on divorce. During the coronavirus pandemic, there's been a significant increase in the amount of pet owners, and specifically dog owners. And it's safe to say that the current prices of newborn puppies certainly reflect the demand. How many of those owners, however, would have considered what would happen to their pet on divorce? This is not an entirely new concept within the court. A case where the judge was asked to determine this question was RK and RK, where the wife had made a claim for one of the family dogs. Mr. Justice Moylan held that on the evidence that I have heard, it is clear that the family dogs were principally looked after by the husband. A petnup is an agreement between parties which sets out the ownership as well as the future arrangements for the pet. A consideration is also given to the financial aspect, for example, vet payments, insurance and food for the pet. In legal terms, pets are considered to be chattels or personal possessions. Chattels are most often things you can move, such as furniture, jewellery, but it also has a wider definition that includes pets. In divorce cases, the court's focus will naturally be on the finances and the children, and not essentially the pets. Having a petnup in place, however, will give you a peace of mind as to what would happen to your dog in the future, and it would also avoid any confusion or misunderstanding down the line.